Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. This is part 4 of Civil Judge Junior Division Judicial Magistrate of First Class Preliminary Examination held in 2016 at Maharashtra. We have already discussed question number 1 to question number 75 in last 3 videos. Links of those videos are mentioned in description box. Please go through it. For this video, we will discuss from question number 76 to question number 100. So without further delay, let's get started. Now question number 76. Court of Chief Judicial Magistrate may pass a sentence of imprisonment for a term. Option number 1, not exceeding 5 years. Option number 2, not exceeding 3 years. Option number 3, not exceeding 7 years. Option number 4, not exceeding 10 years. And the correct answer is option number 3, that is not exceeding 7 years. Now question number 77. Which of the following is or are the correct propositions? In a part heard trial of a criminal case, A. Succeeding magistrate can act upon the evidence recorded by his predecessor. B. Succeeding magistrate cannot act upon the evidence recorded by his predecessor. C. Succeeding magistrate cannot act upon such an evidence recorded by his predecessor only in summary trial. Option number 1, A only is correct. Option number 2, A and C are correct. Option number 3, B only is correct. Option number 4, none of the above. And the correct answer is option number 2, that is A and C are correct. It means succeeding magistrate can act upon the evidence recorded by his predecessor and succeeding magistrate cannot act upon such an evidence recorded by his predecessor only in summary trials. Now question number 78. Which of the following is correct proposition? A. Warranty is a stipulation essential to the main contract of sale of goods. B. Warranty is a stipulation collateral to main purpose of contract. C. Breach of warranty gives rise to a buyer to repudiate the contract. Option number 1, A only. Option number 2, B only. Option number 3, C only. Option number 4, A and C only. And the correct answer is option number 2, B only. It means warranty is a stipulation collateral to the main purpose of contract. Now question number 79. Lease for a month to month can be determined by. Option number 1, 30 days notice in writing is given by lessor. Option number 2, 15 days notice in writing duly signed. Option number 3, 15 days notice expiring with the end of the month of tenancy. Option number 4, oral notice by lessor. And the correct answer is option number 2, 15 days notice in writing duly signed. Now question number 80. Minor can institute a suit for recovery of movable property. Option number 1, within 1 year after he attains majority. Option number 2, within 3 years after he attains majority. Option number 3, within 3 years from the date of cause of action through next friend. Option number 4, within 12 years after he attains majority. And the correct answer is option number 2, within 3 years after he attains majority. Now question number 81. Which of the following contract cannot be specifically enforced? A. A party is unable to perform whole of the contract and the part which cannot be performed is small and admit compensation in money. B. A contract which is dependent on the personal qualification or volition of the party. C. A contract which is in its nature determinable. D. A contract for the non-performance of which compensation in money is an adequate relief. Option number 1, all the above. Option number 2, A, B and C. Option number 3, B, C and D. Option number 4, A, C and D. And the correct answer is option number 3, that is B, C and D. Now question number 82. Landlord is entitled to inspect the premises. Option number 1, at any time even without prior notice to the tenant. Option number 2, at any time giving prior notice to the tenant. Option number 3, at a reasonable time giving prior notice to the tenant. Option number 4, during daytime only giving a notice to the tenant. And the correct answer is option number 3, at a reasonable time giving prior notice to the tenant. Now question number 83. When is a notice of execution under Rule 22 of Order 21 Civil Procedure Code necessary? Option number 1, as a rule in all execution cases, show cause notice is needed to be given. Option number 2, when warrant of possession of immovable property is sought in execution. Option number 3, when execution is filed more than 2 years after date of decree. Option number 4, when execution is filed by legal representative of the decree holder. And the correct answer is option number 3, when execution is filed more than 2 years after date of decree. Now question number 84. What is the period of limitation for taking cognizance of the offence under section 326 of Indian Penal Code? Option number 1, 5 years. Option number 2, 3 years. Option number 3, 7 years. Option number 4, no period is prescribed. And the correct answer is option number 4, no period is prescribed. Now question number 85. Which of the following confession made by the accused is admissible? Option number 1, voluntary confession made to the police officer. Option number 2, confession caused by threat, inducement, proceeding from person in authority, having reference to the charge against accused, etc. Option number 3, voluntary statement made in police custody. Option number 4, voluntary confession made while in police custody but made to the magistrate. And the correct answer is option number 4, voluntary confession made while in police custody but made to the magistrate. Now question number 86. Which of the following are the correct propositions? A, minor can be admitted as a partner. B, minor cannot be a partner but may be admitted to the benefits of partnership. C, minor admitted to the benefits of partnership can have access to the accounts of firm. D, such a minor is not personally liable for an act of the firm. Option number 1, A, C and D. Option number 2, B, C and D. Option number 3, A, B and D. Option number 4, A and C only. We have to find correct proposition, and the correct answer is option number 2, that is B, C and D. It means minor cannot be a partner but may be admitted to the benefits of partnership. Minor admitted to the benefit of partnership can have access to account of the firm, and such a minor is not personally liable for an act of the firm. Now question number 87. A committed theft of 2 gold chains of B, who is a resident of Pune, but from a place in Mumbai, one chain was recovered from C at Jalna, another from D at Buldhana. C and D purchased the chains knowing them to be stolen property. Which court can inquire and try the offence? Option number 1, court in Mumbai only. Option number 2, court at Jalna or Buldhana. Option number 3, court in Mumbai as well as Jalna and Buldhana. Option number 4, court in Pune. And the correct answer is option number 3, court in Mumbai as well as Jalna and Buldhana. Now question number 88. Which of the following properties can be attached in execution of money decree? Option number 1, cooking utensils, beds, etc. Option number 2, implements of husbandry. Option number 3, books of account. Option number 4, share in the corporations. And the correct answer is option number 4, share in corporations. Now question number 89. If a landlord without a just cause cuts off or withhold essential supply or service enjoyed by the tenant, he or she is liable to be punished with imprisonment for a term. Option number 1, which may extend to 1 month, or a fine which may extend to rupees 1000, or both. Option number 2, which may extend to 3 months, or a fine which may extend to rupees 1000, or with both. Option number 3, which may extend to 3 months and a fine which may extend to rupees 1000. Option number 4, which may extend to 1 month and a fine which may extend to 1000. And the correct answer is option number 2, which may extend to 3 months, or a fine which may extend to 1000, or with both. Now question number 90. Which of the following courts has got inherent powers to make order in criminal proceeding, to prevent abuse of process, or to secure ends of justice? Option number 1, Court of Session. Option number 2, Chief Judicial Magistrate. Option number 3, High Court. Option number 4, all the above. And the correct answer is option number 3, that is High Court. Now question number 91. Objection to the jurisdiction of the court can be entertained. Option number 1, in appeal also for the first time. Option number 2, during trial of the suit. Option number 3, at any stage of the suit. Option number 4, if taken at the earliest opportunity or before settlement of issues. And the correct answer is option number 4, if taken at the earliest opportunity or before settlement of issues. Now question number 92. A man deliberately did an act and frightened a girl of weak heart who felt unconscious. What offence, if any, has he committed? Option number 1, under section 323 Indian Penal Code. Option number 2, under section 326 Indian Penal Code. Option number 3, under section 325 Indian Penal Code. Option number 4, no offence. And the correct answer is option number 1, under section 323 IPC. Now question number 93. Act of the child is no offence when the child is. Option number 1, under 8 years. Option number 2, under 10 years. Option number 3, under 12 years. Option number 4, under 7 years. And the correct answer is option number 4, under 7 years. Now question number 94. The term legal representative means. Option number 1, the legal heir of the deceased party. Option number 2, a person who in law represent estate of the deceased party. Option number 3, a person nominated by deceased party. Option number 4, other relatives though they are not legal heirs. And the correct answer is option number 2, a person who in law represent estate of the deceased party. Now question number 95. Which of the following authorities is not a state for the purpose of Part 3 of the Constitution of India? Option number 1, government companies. Option number 2, public sector undertaking. Option number 3, municipal corporation. Option number 4, Board of Control for Cricket of India, that is BCCI. And the correct answer is option number 4, Board of Control for Cricket of India, that is BCCI. Now question number 96. When is a person eligible for appointment as a district judge? Option number 1, if he has been an advocate for not less than 7 years. Option number 2, if he has practiced as an advocate for more than 3 years. Option number 3, if he has been an advocate for not less than 5 years. Option number 4, if he has practiced as an advocate for a year. And the correct answer is option number 1, if he has been an advocate for not less than 7 years. Now question number 97. Every agreement between landlord and tenant for letting out the premises is required to be option number 1 in writing and registered. Option number 2 in writing and registered if it is for a period 1 year or more. Option number 3 in writing but it need not be registered. Option number 4 in writing and registered if it is for a period 3 years or more. And the correct answer is option number 1 in writing and registered. Now question number 98. Which of the following is an incorrect proposition? Option number 1 admission may be a statement oral or written. Option number 2 admission is conclusive proof of the fact admitted. Option number 3 maker of the admission may prove that it was erroneously made. Option number 4 admission can be used against its maker or his representative in interest. And the correct answer is option number 2 admission is conclusive proof of the fact admitted. Now question number 99. A handed over 200 kg tur dal to B, a carrier, to carry it to his town. B carried it to his own village dishonestly. What offense has B committed? Option number 1 criminal misappropriation of property. Option number 2 criminal breach of trust. Option number 3 theft of property. Option number 4 no offense. And the correct answer is option number 2 criminal breach of trust. Now question number 100. Suit filed after the prescribed period of limitation. Option number 1 has to be dismissed when objection is raised in defense. Option number 2 has to be dismissed even though no objection as to limitation is raised in defense. Option number 3 has to be dismissed unless sufficient cause for the delay is shown. Option number 4 can be entertained and decided on merit if court considered it just and proper. And the correct answer is option number 2 that has to be dismissed even though no objection as to limitation is raised in defense. That's it for today. We have solved total 100 questions of Civil Judge Junior Division, Judicial Magistrate of First Class Preliminary Examination held in 2016 at Maharashtra. Previously, we have solved Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2011, 2012, 2014 and 2015. Links of those videos are mentioned at description box. Please go through it. In upcoming videos, we will solve the Civil Judge Junior Division, Judicial Magistrate of First Class Preliminary Examination held in 2017. So stay tuned and don't forget to subscribe my channel and hit on a bell icon so that you will get notification of upcoming videos. Thank you.